get a good look. I remember back in the early 2000s when this book was floating around the conscious community. This is one of the first books that I read coming into the conscious community. This book was floating around the BOP like heavy. And today, I'm going to share some of the contents of it with you. Now, this guy, William Cooper, this guy is like naval intelligence. He's seen a lot of things. And the things he's revealed in this book, unfortunately, they, I would say like the men in black, the real men in black, like came to see about him. And I think they knocked him off for the things that he revealed in this book. He even said himself that, like government like black cars used to be outside his house and everything. I think he even claimed that one tried to run him off the road one time. Yeah. It's heavy. Real heavy. All right. Without further ado, let's go here. Chapter 13. Treason in High Places. United Nations Treaty. United Nations Participation Act versus the sovereignty of the United States of America. At the conclusion of the Constitutional Convention in September 1787, Benjamin Franklin was asked, "Well, doctor, what have we got, a republic or a monarchy?" He answered, "A republic if you can keep it." It's interesting. We have a republic. Can we keep it? United States Constitution, Article 6. All debts, contracted, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Do you know what that means? All debts contracted and engagements entered into before the adoption of this Constitution shall be valid against the United States. What does that tell you? That tells you that your ancestors, the Aboriginals, the American Indians, the Moors, the ones who's labeled black, Negro, colored, African American in this modern society, all their debts were discharged.
Yeah.
Because the debt is on the United States of America. You see that. It's telling you that. All debts that was contracted and entered into before this Constitution is valid against the United States. It's on the United States, not you. This is in the Constitution. You can use this as a way to discharge your debt. When these bill collectors are asking you for payment for something, what are you talking about? All my debts is under the United States. They're the ones supposed to be taking care of that. Right? Okay, let's continue. This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made, or which shall be made, or which shall be made. See that? Under the authority of the United States shall be the supreme law of the land. All treaties our ancestors made with the United States, supreme law of the land. And the judges in every state shall be bound thereby. Anything in the constitutional laws of any state to the contrary, notwithstanding. So the judges, all of them are supposed to be bound by the Constitution that they take oaths under. Right? Supreme law of the land. The treaties. Come on, man. The senators and representatives before mentioned, and the members of the several state legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath, didn't I just say that, or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any officer or public trust under the United States. Right? This is Article 6, United States Constitution. They're supposed to be following this. Okay, let's go. Have we already joined a one world government? U.S. sovereignty, fact or fiction? The executive, judicial, and legislative branches of the U.S. government have followed the policy that the United Nations Treaty approved under the UN Participation Act of 1945 on behalf of the United States of America. On behalf of the United States of America. By Harry S. Truman and the United States Senate, which treaty supersedes the United States Constitution under the terms of Article 6 of the United States Constitution. The Council of Foreign Relations created the United Nations. Their member agents, Alger Hiss and Leo Pavlovsky, did the paperwork, but the honors went to a special committee appointed by President Roosevelt to draw the first draft of the charter. The members of the committee were Summer Wells, Isaiah Bowman, see that right? Hamilton Fish, Armstrong, Benjamin Cohen, and Clark Egenberger, all members of the Council on Foreign Relations and members of a secret order of the quest called the Jason Society. Let's read that again. All members of the Council on Foreign Relations and members of a secret order of the quest called the Jason Society. The Jason Society. The charter was rushed through the U.S. Senate without printed copies to guide the senators. It was explained to them by the Russian-born revolutionary Leo Pasvolsky. The charter conferred no real power on the General Assembly. All the power was in the Security Council, where the veto was the Senate. The Senate would not have ratified the charter except that the American delegation had a right to veto if our interests were threatened by action of other members. Included in this charter was and is Article 25. Member nations agree to accept and carry out the decisions of the Security Council in accordance with the present charter. No restrictions, no reservations. This is all of Article 25. Note the word presence, indicating that there might be other charters. The veto was a hindrance to world government. It had to be circumvented. In 1950, the General Assembly, without any legal authority, met and adopted what they named the Uniting for Peace Resolution. This greatly expanded since that time, permitted the General Assembly to exercise the powers of the Security Council. I bet you didn't know that. The government of the United States recognizes the legally amended charter as the law of the world. Read that again. The government of the United States recognized the legally amended charter as the law of the world, overriding our Constitution. The General Assembly has for years been making the law of the world by ratifying resolutions by a 2/3 majority vote. When the resolution is ratified, it is sent down to a chief executive of the member state. An executive is obliged to accept and carry out the provisions in the resolution. The government concerned must ignore, abolish, revise, and rescind laws in their territories that conflict with the resolution of the General Assembly, and to pass other laws that will put these resolutions into force. One man, one vote comes through resolution number 1760. There are more than 2,000 of these resolutions now in effect. They are the law of the land. Our civil rights laws, the ex post facto sections of which come from the Nuremberg resolutions, our agricultural laws, our health and welfare laws, our labor laws, our foreign aid laws all come from resolutions of the General Assembly or treaties of the UN ratified by our Senate. Not our Senate. Any law passed in your state will be rescinded or abolished if it is in conflict with resolutions of the General Assembly. I can tell you with no reservations whatsoever that all of the intelligence organizations of the United States work directly for the United Nations in concert with the secret government toward the sole purpose of the destruction of the sovereignty of the United States of America and the bringing about of a one world government. The authority cited for their efforts is Article 6 of the Constitution, the United Nations Treaty, and the UN Participation Act of 1945, signed by Harry S. Truman with the advice and consent of the U.S. Senate. This should help you understand how our laws are being made and who is making them. Ask your senators, congressmen, and state legislators if they are aware of these facts. The following statement was made by Mr. Carl B. Ricks of Milwaukee, former president of the American Bar Association, before a Senate subcommittee that was hearing testimony on the proposed Bicker Amendment. It was entered into the House record by Honorable Lawrence S. Smith, Wisconsin, on May 11, 1955. Congressional Record, page A3220. Statement of Carl B. Ricks, Milwaukee, Wisconsin. I appear in favor of the amendments. Congress is no longer bound by its constitutional system of delegated powers. Its only test is under the obligatory power to promote human rights in these fields of endeavor: civil, political, and economical, social, and cultural. These are found in Article 55 and 56 of the Charter of the United Nations, a ratified and approved treaty. They are being promoted in all parts of the world by the United Nations. Congress may now legislate as a uninhibited body with no shackles of delegated powers under the Constitution. Congress may now legislate as an uninhibited body with no shackles of delegated powers under the Constitution. Our entire system of a government of delegated powers of Congress have been changed to a system of undelegated powers without amendment by the people of the United States. The authority for these statements is found in a volume entitled Constitution of the United States of America, annotated, issued in 1953, prepared under the direction of the Judicial Committee of the Senate of the United States and under the chairmanship of Professor Edward S. Corwin of Princeton, aided by the legal staff of the Library of Congress. This is the conclusion on page 427 of the annotations. In a word, the treaty power cannot purport to amend the Constitution by adding to the list of Congress unenumerated powers, but having acted, the consequence will often be that it is provided Congress with an opportunity to enact measures which independently of a treaty Congress could not pass, and the only question that can be raised as to such measures would be whether they are necessary and proper measures for the carrying of the treaty in question into operations. Ain't that something? Isn't that something? What is that telling you? It's plain and simple. They're going completely around the Constitution. They're not even a constitutional government anymore. It's basically over with. These people are rogue. The gig is up. You see what I'm saying? It's over with. Let's see here. Continuing. The Bicker Amendment, which would have changed this, was not passed. A letter to the editor. Right? Georgia, Texas, News Herald, Sunday, November 11th, 1962. Replying to your letter, October 12th, also challenges for November 1961, quoting Patrick Henry on treaties. In the first place, Patrick Henry was and is no authority on either treaties or the Constitution, and B, oppose it. If it is too late to do anything about reinstating our Constitution, then why not just accept the traitorous UN Charter Treaty without any more ado? Why didn't the American revolutionists think it's too late or too difficult to defend their liberty? And if the highly intelligent framers of the Constitution were well aware of the death trap incorporated in Article 6, why then did they so frame it? Did they not expect patriots rather than treasonous as our elected officials to honor and enforce the spirit, letter, and intent of the Constitution? I note you say that according to a law dictionary, the terms legal and lawful are almost one and the same. Agreed, almost, but are not quite. I believe there is a fine line of difference. Taking us into the UN may seem to have been done legally by president and senators, but the act is still unlawful because it is unconstitutional. And the Constitution is the supreme law of the land. All renowned and genuine constitutional experts such as Theos M. Cooley, Theos Jas Norton, and Harry Outwood, to name several, have always held that anything which controversies, diminishes, or perverts the Constitution is null and void and of no effect. Neither the President or Senate has authority or power to change, diminish, or destroy the Constitution by usurpation, treaty, or otherwise. Only a constitutional amendment can lawfully change it. The Constitution is a contract that we, the people of the USA, made with one another, which sets up the machinery of government to carry out this contract, mainly for the purpose of protecting individual rights, as well as state rights, against the powers of government. And no public official has a right to override the provisions of that contract. To quote Theos Jan Norton's Constitution of the United States, its application, etc. A law of Congress, to be one of the supreme laws, must be made in pursuant thereof, and not in conflict with the Constitution. When not made in pursuant thereof, it is of course unconstitutional and of no effect. And the same would be similarly applied to a wonderful decision rendered by the Supreme Court or a lawful treaty. And from Norton's undermining the Constitution, which quotes Alexander Hamilton in number 33 of the Federalist, it will not, I presume, have escaped observation that it is expressly confines the supremacy to laws made pursuant to the Constitution, emphasis by Hamilton, and from the general government to claim no powers which are not granted to it by the Constitution, and the powers actually granted must be such as are expressly given or given by necessary implication. Anyone with the presumed intelligence to be president of the U.S. must know that he cannot lawfully make any such far-reaching treaty with the United Nations or any foreign power as you envision by your language, without laying himself open to the charge of treason under Article 3, Section 3 of the Constitution. Just ordinary common sense is required to know that our alleged treaty with the UN and acceptance of all the inclusion terms with the Charter by our presidents, beginning with FDR, who connived with Stalin at Malta for setting up of the UN in the USA, and our Senate, is a violation of our sacred oath, is a violation of their sacred oath of office as per Article 3, Section 2 of the Constitution. I